Good morning, Mr. Nagel.
Chief Justice and Associate Justices, may it please the Court. My name is David Nagel, and with me is my partner, Bill Halpkin. We represent the appellant in this case, Town Fair Tire. This case is here on appeal from the Appellate Tax Board. Town Fair Tire seeks abatement of use taxes collected in connection with sales at 3 New Hampshire stores. The use tax is a protective tariff that becomes due not on sale, but rather upon importation of goods into the Commonwealth.
But the vendor has an obligation to collect the use tax.
The vendor does have an obligation to collect the use tax under Section 4. Although in this case, our contention is that the only reason we have a use tax is that the federal Constitution prohibits the Commonwealth from taxing sales that occur beyond its borders. And in substance, the Commissioner in this case is attempting to do through a use tax what it cannot constitutionally do through a sales tax.
Would you feel, how important is it to your argument that the Commissioner is relying on the inference that these automobiles, or vehicles anyway, were registered and registered in Massachusetts? In other words, what I gather from the record is there is no evidence, affirmative evidence, that that is the case. The inference is drawn because Massachusetts driver's licenses and some Massachusetts addresses. But I'm just wondering whether, if the evidence were very clear that every single one of these vehicles had a Massachusetts registration and inspection sticker, and that was part of your client's records, would it be any different in your view?
No, Your Honor, it wouldn't. And I think it would not, because we would draw the line further back. That is, when we look at Section 4, our position is that Section 4 imposes no duty on a vendor to inquire where a customer is going to use goods after they take title and possession, much less any duty to guess, based on other facts and circumstances, where that property is going to be used. Section 4, in our view, reflects the general rule that a vendor's obligation to collect use tax, like its obligation to collect a sales tax, is limited to the tax applicable at the location where the customer takes title and possession.
So you would make no, the item being sold doesn't matter to you at all?
No, it definitely does not matter. In fact, our view is that if this Court were to find that the Board's ruling is correct, whatever rationale the Court would need to rely on would be applicable to any type of property.
No, I mean, because, you know, if you just take the Miller case, I mean, I think that the government makes this argument, but that cash and carry is very different from tires on vehicles that you know, reside somewhere, and usually it's where they are licensed, I mean, where they're registered and inspected, et cetera, et cetera. So if that is Massachusetts, that's an inference that is a whole lot stronger than some very portable item that you buy in Delaware and may or may not take into Maryland.
I think, in fact, though, a cash and carry or an over-the-counter transaction, by which I mean simply a transaction where a customer takes possession of the good at the retailer's location out of state, in any circumstance like that, I think there's no use tax collection obligation unless, under Section 4, the vendor either, well, there's just no use tax collection obligation in that situation. Section 4 doesn't require it. And I'm not trying to say that Section 4 doesn't ever require a vendor to collect use tax. It would require a vendor to collect use tax if title passed outside Massachusetts, but at the time title passed, the property was in Massachusetts, or immediately afterwards, the vendor took steps to ship the property into Massachusetts.
So like mail order, something like that.
Exactly, a mail order case.
Or delivery.
Or
made arrangements to have the property delivered
Right.
into Massachusetts.
In either case. And in fact, the Commissioner of Revenue has addressed just these types of situations.
And the only reason you are here, in some respects, is because Town Fair actually does business in Massachusetts. If you didn't do any business, if you had no tire stores in Massachusetts and just had one in New Hampshire, you wouldn't be here.
That's correct, Your Honor.
Clearly, the Commissioner wouldn't have the authority to force you to collect this tax under those circumstances.
That's correct.
Because of due process reasons? That would be why?
Yes, and because of Commerce Clause protections under Quill.
Right, although even with the stores, you would still make the Commerce Clause.
I mean, I think on the constitutional claims, our view is that in American Oil, Miller Brothers, and Montgomery Ward, the courts rejected use tax collection obligations where a vendor was responsible for shipping property or directing property into the taxing state. And the court in National Geographic distinguished these types of situations from a typical mail order sale. In a typical mail order sale, I think the vendor is rightfully bound to collect the tax because they're in control of the property and they put it into the taxing jurisdiction. The California Supreme Court, in its National Geographic opinion, I think does a good job outlining the types of due process concerns that Town Fair Tire has tried to raise here, and also does a good job distinguishing between the arguments that were made by the taxpayers in Miller Brothers, American Oil, and Montgomery Ward from the losing argument of the taxpayer in National Geographic. If I could go back to the text of the statute for just a second, the situation, and I think it's important to recognize that there are circumstances where a vendor would have to collect the tax. To take two examples that the Department of Revenue has addressed in letter rulings. Suppose that an art dealer sells property out of state to a customer, but doesn't immediately transfer possession. So the dealer remains in possession of the property.
This is a Massachusetts art dealer?
This is a dealer that does do business in Massachusetts, yes.
Okay.
Sale takes place outside Massachusetts. If subsequent to that sale, the property, the artwork, were to be shown on display here in Massachusetts, the dealer would be obligated to collect a use tax. The Department of Revenue addressed that in letter ruling 9814. Or consider another example.
That's because there's public notice?
I think in that case, it's because the dealer holds the property on behalf of the customer, and the dealer is involved with putting the property into the Commonwealth.
But in that case, the dealer, I assume in your hypothetical, is not the vendor.
The dealer is the vendor in that case. Yeah. It's the dealer, the vendor who sold the artwork to the customer but retains possession.
Suppose you have a customer who goes to New Hampshire to buy tires, and he says at the time of purchasing the tires, I'm here because the tires are so much cheaper than in Massachusetts, and I'm going to drive back to Massachusetts and just save the difference in the cost.
I think our position would be that the dealer still under Section 4 has no duty to collect the tax. The dealer might well tell the customer that they have a use tax collection obligation, and that under statutory presumptions, if they return to the Commonwealth of Massachusetts within 6 months, their purchase will be deemed to be for use in the Commonwealth. And under this Commonwealth's, the Commissioner's regulations, that customer will indeed be required to self-assess and remit a use tax to the Commonwealth.
But no duty on the part of the seller, even though they have the knowledge that...
That's correct, Your Honor. We believe absolute knowledge that a retailer might have that goods are going to be used in the Commonwealth does not, under Section 4, require them to collect a tax, so long as title and possession pass outside the Commonwealth. That, we would say, is the general rule. That's the bright-line rule that retailers and vendors have followed. What the Commissioner has done, in effect, in this case, is to divorce the location where you... The Commissioner has asked vendors to look beyond the point where title and possession pass to some point of intended use to make an educated guess about where property will eventually be used. And our view is that insofar as a use tax is limited to consumption within a state, intended consumption within a state is not the proper subject of a use tax. So under Section 4, if anything is clear, it's clear that at the time of sale, goods in New Hampshire are not being stored, used, or consumed in Massachusetts. So no use tax liability arises at the time of sale. It's equally clear that in the context of an out-of-state, over-the-counter sale, once the customer has left the retailer's out-of-state location, the vendor is in no position to collect a use tax. The legislature could not have intended to require vendors to collect a use tax preemptively or to collect a use tax when it was not in a position to do so.
You mentioned, and I'm hoping you can refresh my recollection, you say there is, some states have language in their use tax statute that might reach this, and what is the difference?
I think we would question whether or not those statutes are constitutionally permissible.
Okay,
But those statutes, I think, as we have raised them, go to the question of who has the burden of proving that, as between the Commonwealth and a vendor, who has the burden of proving that use tax ought to have been collected. The only statutory presumptions in the Commonwealth of Massachusetts are presumptions that sales from out of state for delivery into the Commonwealth are sales for storage use or consumption. That's Section 8A in Chapter 64I. And in that case, if there is a delivery into the Commonwealth, the vendor has the burden of showing that it was not for storage use or consumption.
Now, I think just the second half, or the backside of your argument, is that the use tax may in fact be due, but it has to be paid by the customer in Massachusetts.
Absolutely, Your Honor.
Under Section 2.
Our case is entirely about the scope of the vendor's collection obligations, and we have nothing to say about liabilities that customers may incur when they purchase taxable property out of state and use it within the Commonwealth of Massachusetts.
So let me ask you this. I have a son goes to the University of New Hampshire. The car's registers at my home, and lives up at the University of New Hampshire. He goes to one of the stores, purchases tires, and then just drives back to the University of New Hampshire, and 9 months later comes home for the summer. Would there be a use tax obligation in Massachusetts?
No. I think the Commonwealth of Massachusetts in that situation would not be able to rely on the statutory presumption that a customer who purchases goods out of state and then returns to the Commonwealth within 6 months purchased them for use. I think if I were representing your son, I would say he didn't purchase the goods, the tires, for use in the Commonwealth. And so he didn't satisfy that prong of the requirements under Section 2.
But if he bought them in April with the school year ending in May, you couldn't make that argument.
He could not make that argument, and he would have to show that, in fact, he had actually purchased them for use in New Hampshire. And once they're brought back into the Commonwealth, technically speaking, a use tax would be due.
Even if they were only brought into the Commonwealth for a month, and then you returned to school, and for the rest of the calendar year, they were used in New Hampshire.
The Commonwealth does not distinguish use tax liabilities based on the amount of time the property is actually used here in the Commonwealth. And for that matter, I think the use tax law is not limited to Massachusetts residents. This case has been framed in terms of a liability that residents may have.
But it's anybody.
But it could be anybody.
So if a New Hampshire resident purchased tires at your store and drove into Massachusetts, they might actually be required to pay a use tax?
Yes, Your Honor. That's exactly what the board's ruling implies.
But what would you have to do then? Apportion the tax between the amount of miles that the person drives in different states?
In the sales and use tax context, states rely on crediting mechanisms as opposed to apportionment like they might in the income tax context. But it's by no means certain that a crediting mechanism would actually work. Take, for example, a situation where somebody purchases tires or goods in New Hampshire. The vendor makes an educated guess that those goods are going to be used in Massachusetts and so collects a Massachusetts use tax. The customer then, instead of driving immediately to Massachusetts, drives to Vermont or Maine, which have a 6% and 5% sales tax rate. The customer would incur a use tax liability in either one of those states. If a crediting mechanism worked correctly, that Vermont and Maine would recognize a credit for tax that had been collected and remitted to Massachusetts. But in fact, Vermont and Maine might well deny that on the grounds that sales use taxes that are incurred take precedence over sales taxes that are paid first. So Vermont and Maine would say, there hasn't been any actual use in Massachusetts. We're not going to give a credit. And in fact, there's been actual use here. And in that case, there could be a pyramiding tax liability for a customer, which goes beyond the problem we see in sort of extending by implication the scope of Section 4.
So this is a tip of a gigantic iceberg.
I mean, just maybe two more examples. I see my time is very limited. But
Well, maybe you can give the two examples in answer to, I don't think there was a question, Justice
No.
Wood. I think it was a declarative
Shock
statement.
observation.
So here's the question I'm interested in. You take the position in your Rule 16 letter that the Commissioner has taken inconsistent positions in this litigation with respect to what is it still a she's doing nationally, with the streamlined sales tax. Why are those positions inconsistent?
The point we were making in response to Amicus Cost's discussion of the streamlined sales and use tax agreement is that the current sales and use tax laws in the Commonwealth adopt the destination principle, the principle that an obligation to collect sales and use tax is limited to the tax applicable where title and possession pass. Insofar as the history regarding the Commonwealth's adoption or movement towards streamlined sales and use tax indicates that current law follows the destination principle and that current law is consistent, the Commissioner's position in this case with respect to out-of-state over-the-counter sales is inconsistent.
Thank you, Mr. Nagel.
Thank you.
Mr. Guberin?
Madam Chief Justice, and may it please the Court, let me begin with this alleged inconsistency.
Before you get there, maybe I'm missing something, but what authorizes the Commonwealth of Massachusetts, the taxing people here, to impose the collection of a tax on a company that does business in New Hampshire? The collection of it.
It's because the company does business in Massachusetts as well. There is
No. So if the company didn't have any stores in Massachusetts, say that Town Fair Tire Centers had just operated in Maine, New Hampshire, and Vermont, but all the other facts are the same, then what is your position?
Then, under the current understanding of Miller Brothers, there would be no obligation on the part of Town Fair Tire to report.
Well, is that logical? Just the fact that they have a few stores here, that makes it logical that you collect the use tax on them? But if they didn't, if they closed their Massachusetts stores, then they wouldn't have any. But how does that make logical sense if you're going on the basis of use in Massachusetts?
Well, if Your Honor please, there is an argument that has been made, for example, by Justice Blackmun in his concurring opinion in National Geographic, that the distinction that Miller Brothers seems to draw is inconsistent with National Geographic. And if that were to become the doctrine of the Supreme Court, then not being in Massachusetts well might not allow Town Fair Tire to escape liability. But under the law as it is understood today, all that is necessary to make it constitutional to impose a burden is that there be a sufficient nexus, a substantial physical presence in Massachusetts.
I take it the statute also requires, if you read the statute, every vendor engaged in business in the Commonwealth.
Yes. That's the
one of the conditions.
That's the statutory basis. But in terms of the logic, there were two questions here.
Yeah.
One is there a sufficient connection between the business on which the obligation has been put so as to make it constitutionally permissible? The other question is, what is the Commissioner's authority for saying that we can make them remit use tax on a sale that took place outside Massachusetts? And the answer to the first question is has been settled by the Supreme Court for a long time, and most clearly perhaps in National Geographic. Quill, my brother, mentioned physical presence, although some commentators think that that's a silly bright line to draw, is nevertheless the bright line that the Supreme Court has drawn.
For sales and use tax.
For sales and use taxes in terms of whether or not it is constitutionally permissible to subject a vendor to a tax obligation. Now, with respect to collecting the tax, there's nothing novel about a vendor having to collect a tax, or let me say about collecting a tax, on a sale that takes place out of state and before the goods come into Massachusetts.
As a mail order.
Exactly. That's National Geographic.
But in that situation, if there's a mail order, there is a certainty that the item will be delivered into Massachusetts. If the tires are purchased just over the line in New Hampshire, the vendor doesn't know if the person is on their way to take a trip around the country, if they're leaving the state of Massachusetts, and isn't the kind of inquiry that you would require in order to establish use in Massachusetts an impermissible burden on interstate commerce?
No, Your Honor. First, there is no absolute certainty in the mail order case. The mails sometimes go astray. If the vendor...
But that's an unlikelihood.
But the vendor is shipping it into Massachusetts it's essentially for use in Massachusetts.
That's correct.
Shipping it into the state.
And on the particular facts in this case, Town Fair Tire is essentially doing the same thing.
That's not essentially. I mean, you've got your counterpart in New Hampshire saying, I need a black line rule. So it can't be essentially.
It is the same, Your Honor. And here is the bright line rule. We're dealing with goods or objects, here automobiles, other motor vehicles, that are registered to a particular location, here Massachusetts.
Well, you're inferring
You're
that.
inferring that.
Well, the board, I suggest, warrantably infers that in the absence of any evidence to the contrary from the fact that the people who come there are identifying themselves as coming from Massachusetts. And given the fact that the
That
cars...
they have Massachusetts licenses.
Well, in some cases, Massachusetts licenses, not in most of the cases. But in the 313 cases we're dealing with, the invoices and the record, they gave Massachusetts addresses and very often Massachusetts phone numbers. The Massachusetts address establishing where they live is enough to tell us, in the absence of any other information, that the car is going to go back to Massachusetts. And I might say parenthetically that one way a vendor like Town Fair Tire could relieve itself of the obligation in a case like this would be to take some sort of written statement analogous to the resale certificate or tax-exempt certificate that's already used in Massachusetts.
Or not gather the information. Give me your cell phone number. We'll take the VIN off the car and an email address.
Or not gather the information. For their own business purposes, they have been gathering the information.
Why do they need all that information? Typically, when you make a purchase, when a person makes a purchase at a store, all you do is give your credit card in 2 seconds and you're out of there. And they don't take addresses and phone numbers.
My understanding of the testimony is, Your Honor, that they take the information because they are providing a warranty that is nationwide, not just in the state of sale, and for recall information. But that's their business choice. If they want to change the model on which they do business so that, as far as they're concerned, when they make a sale, there's a realistic possibility that the goods are not intended for use in Massachusetts and will not return to Massachusetts, then the commissioner would not be seeking to hold them liable.
But if you're standing here, let's assume they did not collect the information. Wouldn't you be saying that's willful blindness? The car's in the lot. They have to collect the information.
No, I would not, Your Honor.
All right. So then it's over. The case is over. They don't collect the information. No harm, no foul.
Doesn't
Well-
that seem peculiar, that whether or not a tax is imposed depends on what information the vendor collects?
No, Your Honor, because the question is whether or not the vendor is acting in good faith and whether it has reason to know or doesn't have reason to know that the goods in question are both intended for use in Massachusetts and are going to be used in Massachusetts. If I could say one more thing, if the vendor, it may well be, if we had some external proof that we could show that, the cars were in New Hampshire and they had Massachusetts plates, then after the fact, Justice Cordy, perhaps we could say that they knew these were, or should have known these were Massachusetts transactions. But as a practical matter, in terms of auditing the company, if there's no Massachusetts information on the invoices, then there's no way to audit.
Does the commissioner, I mean, it seems to me if one says, yes, this tax is permissible, aren't we starting down this path where you're going to have all these factual cases about what the seller knew or should have known about a particular product in a particular location, and is it the kind of product, and do you know enough about whether it's going to be used in Massachusetts, even though you're selling it, 200 miles from the border?
No, Your Honor, because this is a very narrow ruling. It is
It's not. Let me give you this hypothetical. My sister lives in Minnesota. My niece is getting married. I go up to one of those nice, do they still have stores in Kittery? I haven't been there for a while. Okay. I go to Kittery and I buy a nice set of Lenox china. And the sales clerk says to me, do you want to hear about our specials in the future? You bet I do. Where do you live? Massachusetts. What's your cell phone number? Your email number? I get in the car and I take the thing, and the next day I fly to Minnesota.
That would not come under the rule of this case.
Why?
Because there is a realistic possibility in that case, unless you volunteer that you're buying them for your own use in
Well,
Massachusetts.
how are we going to determine the facts in each case? I mean, is the vendor
What's the realistic
supposed to inquire at length of the purchaser, but during which time the purchaser may change her mind and say, I'm not going to buy this?
No, Your Honor. It's a matter of what is readily apparent to the vendor. Here, the customer gave a Massachusetts address.
But only because the vendor required it.
Well, and I'm saying if the vendor doesn't require it, then it's not going to come to the attention of the commissioner. But the cars themselves had license plates on them.
In your case,
Well, you
I
think
get
so.
all these new tires and I drive out to Minnesota and I say to my niece, guess what I'm giving you as a wedding present? I'm giving you my precious 1962 Beetle, but it's got new tires. And I hand it over to her. I mean, what's this poor guy in, New Hampshire doing?
The poor guy in New Hampshire, Your Honor, can rely on a written statement that provides auditable information that the tires are not being purchased for use in Massachusetts. The Supreme Court said in Miller Brothers that the problems of collecting use tax from, or sales tax for that matter, from the individual customer are very grave. And in National Geographic, the court said that necessarily the collection of the tax is imposed on the seller. In Massachusetts already we have provisions that allow exempt transactions not to be covered by the tax.
What do you see as what do you see is the bright line distinction between this case and Miller Brothers?
Well, the bright line distinctions are these, Your Honor.
And don't say because Miller Brothers doesn't do business in Delaware, whichever Maryland, but on this, assume that they both.
In National Geographic explains the differences. Justice Blackmun says that's not a good enough explanation. Miller Brothers can't stand after National Geographic. But according to the majority in National Geographic, the primary difference is that the seller in Maryland had no knowledge or control over where the goods were going.
Delaware.
In Delaware. No knowledge or control over where the goods were going, and had no active solicitations. Forget about physical presence. It made no aggressive efforts to get business in Maryland. In this case, the cars, as we said, are registered to a location. The tires are affixed. The tires are affixed to the cars. So we know wherever the car is going, the tires are going with them. And it is not realistic to imagine that the customer is going to drive out of the parking lot elsewhere in New Hampshire, remove the tires from the car, and ride back to Massachusetts on the rims.
All right, so you're saying we're going to import the know your customer rule from securities law into tire sales. The question
No,
I
Your
have
Honor.
is, well, we are. You
you
need to know
don't
your
have to know. If you
customer.
don't know your customer, if you don't have this information, then you have no obligation. A Town Fair tire became subject to this tax
Because they just got too
obligation
much information.
because they got the information for their own business
So
purposes.
go back to my Lennox China thing. So I give them all the information. They say, now that I have the information,
You owe a tax.
I forgot to tell you we've got to impose a little additional tax. I mean, what am I supposed to do? To say I want the information back? Oh, can't take that information back. I mean,
That's right.
I have a question for you. Would you just address this, please? Town Fair Tires, in their brief at page 49, says that many other states have use tax imposition and collection statutes identical or similar to ours, but their research revealed no state statute, regulation, court decision, revenue ruling, or directive that specifically requires an out-of-state vendor to collect use tax on an over-the-counter sale in any circumstance. Is that correct? Would you say that's a correct statement?
I'm not aware of any such case, but I would add first, this is not an ordinary over-the-counter sale. It is very important, essential, that the tires are affixed to the car and the car has a geographic location attached to it.
You say that, but I go to Best Buy in New Hampshire, and they ask me for my zip code when I make, all the stores do this, marketing. They ask me for my zip code. They now know I live in Massachusetts. I've purchased a toaster. I'm likely to bring it home.
Likely is not the same as there being no realistic possibility that you won't.
I
Let me give
purchase
you
a toaster and fill out a warranty application, which has my address in Massachusetts.
Well, in that case, or perhaps another case, but there were only a few that have occurred to us, you go and you buy a computer or a refrigerator, and you sign up for a service warrant plan. And you fill out the service plan, and you put in your addresses where the object is going to be serviced. That is readily apparent information staring the vendor in the face that the goods are going to be used in Massachusetts.
So Massachusetts will be auditing Best Buy and other places to see whether their warranties identify the locations of toasters and televisions and
Or when you buy
refrigerators.
insurance, Mr. Goodman, a lot of times now these big stores are selling you insurance on half the big products they sell. So if you fill those out, then you'd be taking the use tax, you'd be applying the use tax also to some big buy in New Hampshire, if there is one up there that sells their goods here.
Absolutely, Your Honor, if the information is readily apparent to the vendor. And we're not talking about guessing. With the warranty, the service contract, the insurance, there is no guessing about...
You'll need many more people to go out and audit all these companies. You'll
Well,
become
many
nationwide.
fewer than to try to collect from the individual customer. I see my time is up, but I'd like to close with one example.
Wait, let me just ask you one other question along these lines.
answer his question with your example.
I'll try.
If a Sears Roebuck does business in Massachusetts and perhaps all 50 states, I don't know, but somebody from Massachusetts is taking a trip around the country and they stop in, hypothetically, at Custer's Last Stand, and there happens to be a Sears right at Custer's Last Stand. They get a complete set of tires changed, and they buy a suit. And they return to Massachusetts. The state audits Sears's business in Massachusetts, and they say, by the way, we also want all information having to do with sales by Massachusetts customers outside purchases. You say that because they've acquired all this information for business purposes, the state of Massachusetts is entitled to collect a use tax from the Sears in...
I'm not saying that, Your Honor. The difference is if you're out... First of all, there are only 4 states besides New Hampshire that don't collect sales tax. So if you're in Oregon, South Dakota isn't one of them. They do have a sales tax. If you're in Oregon or Montana or Alaska, to pick 3 of them, and you buy a complete set of tires, there is a realistic possibility that you are not buying the tires with an intention to use them in Massachusetts, and that they may be used up before the car gets back to Massachusetts. The difference is, to come to my closing example, if we look in parking lots outside fireworks stores in New Hampshire around the 4th of July and see that most of the cars there have Massachusetts license plates, we can say in the aggregate that it's reasonably certain that most of those customers are buying the fireworks with the intention to use them and bring them back to Massachusetts. But there is a realistic possibility as to any particular customer that the customer is in New Hampshire on vacation and is going to use the fireworks in New Hampshire, and so there would be no obligation. It's not a case, such as here, where there is a car licensed to Massachusetts, the driver comes from Massachusetts, the car with the tires installed is going back to Massachusetts.
Thank you, Mr. Goodman.